it'd be good if you could keep your camera on, but it's entirely up to you. I just think it gives the speaker more of a feeling of the presence of people if he can see you. But not to worry if you don't want to do that. That's fine. It's not a problem. So over to you, sir.
That's great. Thank you, Lawrence. What I'm proposing to do is to go through as quickly as possible. I'm sure you'll all be happy to hear that. The talk on the service outside the jurisdiction, compliance with the Hague Convention and third-party procedure. Now, what I've done is I've also drafted up a short paper, and Lawrence would be able to email that through to you at some time after the talk, and that will just facilitate you to use it by way of reference in the future. So what I've up on, hopefully everyone can see on the left-hand side of your screen, is a PowerPoint slideshow, and that is very much the nutshells of what the paper will be. Now, the topics that I'm going to look at include the following. So the service outside of the jurisdiction and compliance with the Hague Convention. And then that includes Order 11A, Order 11, service in a contracting state to the Hague Convention, service of proceedings on UK-based defendant or third party post-Brexit, and service of foreign proceedings in Ireland. And then also third party procedure, applicable rule and statutory provision and authorities. I just thought that might tie in nicely with the requirements for service as well, particularly in the context of what has happened since Brexit for us, with the additional requirement to seek leave and the time limits. Obviously, if anyone has a question at any stage, please ask, or in the alternative, we can just have questions at the end. I should, of course, firstly have apologised for the talk being on today at 4:30. I thought it was Lawrence who said 4:30, but it was in fact my secretary said it was me, so it's entirely my fault. If anyone falls asleep, that's fine. Just make sure your microphones are off so we don't hear any snoring. Moving on swiftly, you'll see their service outside of the jurisdiction and compliance with the Hague Convention. Very simply, you're a member of the EU or you're a signatory to the Lugano Convention, the Order 11 Rule A is applicable. And that is a very straightforward procedure. Simply put, you must be able to prove that it's one which the court has power to hear and determine. No proceedings between the parties concerned as to the same cause of action are pending in any of the contracting states. And then there's actually the EU service regulation, which was recently updated in July 2022, and that just facilitates the ease of service of documents between contracting states. The Lugano Convention is actually between EU member states and European Free Trade Association members, which actually includes Canada. So that is very straightforward. And all that is required is that there would be an endorsement at the end of the originating summons that would essentially say that the judge has, that the court has power to hear and determine the issues, and you set out under what article of the Brussels 1 regulation recast or the Lugano Convention. And then you also put in the endorsement that there are no proceedings between the parties. Now, if it transpires that the Brussels 1 regulation recast or the Lugano Convention does not apply, well, then we must look at Order 11. And that is trickier, and it is trickier for a number of reasons. First and foremost, and this is something that happens regularly, where people issue the proceedings prior to the actual application for leave to serve. And the rules specifically state that the proceedings should not be issued before there is an application for leave granting an order for service outside of the jurisdiction. So that is something that must be done. The seminal decision is the analog devices decision, and that sets out the requisite proofs, and it also sets out the tests whereby an applicant must satisfy the court in an Order 11 application. Now, we predominantly would be representing defendants, so you might think initially that this is not pertinent to us, but in fact it's very pertinent, and it's very pertinent in the context of third-party proceedings. And therefore it's something that we must have our attention and concentration focused on, so that we can ensure that we are in compliance with the rules with regards to service outside of the jurisdiction when leave is required on third parties. Order 11 itself sets out different categories of cases to which it is applicable. So it's Order 11, Rule 1, and you must fall within one of those specific categories. Order 11, Rule 1F, for example, is in relation to the action arising out of an alleged tort. So the rules require that we must set out in an ex parte docket what rule it is under Order 11 that we believe we should be entitled to join a third party, or in a plaintiff's case to join to bring an application to leave and serve a defendant in proceedings. The courts also require not only that Order 11 is set out in the ex parte docket, the specific rule, but in addition to which we must set out in affidavit certain averements. Now, the case that should be referred to in addition to the analog case is this O'Flynn case. And very unusually in that case, the Court of Appeal decided to give what they described as an exhortation. And without being crude, in effect, the exhortation is a spanking to practitioners to do what should be done that was not being done and that they wanted to be done. And they set out in very clear terms what it is they believe should be done to successfully apply under Order 11. And that set out a paragraph 97 of that decision. And again, all of this is set out in the paper that I've done that Lawrence can send on to you. But very simply what they say is that you must set out the appropriate paragraph in Order 11, Rule 1. Must be set out in the ex parte docket. The correct paragraphs must be referred to in the grounding affidavit. The order that's perfected must also refer to the specific subsection of the rule. And there's also service requirements as well, that it must be served upon the party that is the intended defendant or the intended third party. The tests that must be applied are as follows. The applicant must establish that there is a good arguable case against the prospective defendant. Now, some of you that may have previously or at present deal with judicial review proceedings will know the standard test that would be required may well be a stateable case. But in this instance here, it's a higher standard. It's a good arguable case. And there's a very good reason for that in the minds of the judges, and it's as follows. If you're requiring a party that is outside of this jurisdiction to attend involuntarily and to submit to the jurisdiction of this court, the court must be satisfied that the case that the plaintiff is making against the intended defendant or the intended third party is one that is of a high standard, a good arguable case. And unusually in applications such as this, the courts will consider is if there's an application to set aside the service outside the jurisdiction. They will in fact consider the evidence on affidavit by the intended defendant or co-defendant, intended defendant or third party, as to whether or not the good arguable case test is met. And the court must be satisfied that it is, otherwise they will not grant an application. What often happens in cases such as these is a bland, non-specific averment is given in the affidavit to say by the deponent for the plaintiff, or in our instance for the defendant, to say that there is a good case against the intended defendant outside the jurisdiction or the intended third party outside the jurisdiction. And that is not sufficient. There must be detail given as to why it is believed that there is a good arguable case. So, for example, if it is arising out of tort and it is a personal injury action, a good arguable case could be explained in affidavit by stating that an engineer commissioned on behalf of us as a defendant has examined and investigated the scene of the accident or the device that allegedly caused the accident. And it is that expert's opinion that the intended third party has a case to answer based on a defective part. So that is setting out in clear terms the basis upon which there's a good arguable case. Otherwise, if that is not done, one of the first tests required by the courts will have failed and the application will not be granted. The next test that a judge must be satisfied with in the High Court and also in the Circuit Court is the one that I'm sure you're all familiar with, which is the forum conveniens. And roughly translated, what that means is the appropriate forum. And again, the affidavit grounding the application must set out in clear terms why it is that Ireland is deemed to be the appropriate jurisdiction for the claim. And in fact, Order 11 Rule 2 sets out what the court should look at, and that includes the value of the claim. It includes the availability of and ease with which witnesses will be secured, and the comparative cost and ease of convenience of hearing in this jurisdiction as opposed to the place where the intended defendant or the intended third party are domiciled. And that is something that the court will consider, but the court will not just consider it from the applicant's perspective. The court will also consider it from the intended co-defendants or the intended third party's position. So again, it is not simply sufficient to put in a simple averment to say that the deponent believes that Ireland is the most suitable forum within which to have the proceedings heard. You must set out in terms of detail why it is. So, for example, and possibly a very trite example, but that the accident itself occurred in Ireland, that the vast majority of the witnesses are situate within Ireland, and therefore this is a more appropriate jurisdiction to have it, even though the intended defendant or the intended third party may have to travel from a foreign jurisdiction into this jurisdiction. But that must be averred, and no bland assertion will satisfy the courts to ensure that the forum conveniens is proved. Now, if it is possible to prove to the court, number one, that if the claim falls under one of the subsections of Rule 1, such as Rule 1F, that a tort has occurred, if it's possible then to prove that there is a good arguable case, and also that it is the forum conveniens, the judge will grant leave. Now, this is one thing that I have found when advising defendants, the plaintiffs sometimes feel that that is the end of the case. It's not. And sometimes applicants in the ex-parte environment find that judges perhaps are more willing to listen to what they have to say without testing it to the degree that the Supreme Court suggested it should be tested in the analog case. And by that I mean that us as defendants representing defendants outside of the jurisdiction should test to ensure that Order 11 has been complied with. And it may well be that the order itself has cited the incorrect rule. And this happened recently in a court before Mr. Justice Simons, where the incorrect rule was cited on the face of the order, which was delivered to the defendant. And that had a very serious knock-on effect because the service was deemed to be invalid. And if the service is deemed to be invalid, because the rules require that you must get leave to serve before proceedings are issued, well, then the issuing of the service is invalid. And that could have an effect on the statute of limitations. So therefore, from our perspective as defendants, it's vital that we sit down and assess the validity of the order that has joined or purported to give leave to issue and serve upon the insured as a defendant or in the alternative as a third party. And it is permitted to enter a conditional appearance where the jurisdiction is disputed, but it is up to us then to dispute that the jurisdiction, or sorry, that Order 11 was not properly invoked. But that is something that we should have a watchful eye on. And any service that is defective can be cured by delivering a standard appearance or entering a standard appearance. So we must be cautious to enter a conditional appearance. And that can be done, and the conditional appearance can then be transferred over to being a normal standard appearance simply by open correspondence to say that the conditional appearance is now withdrawn and that we are entering a non-conditional appearance on behalf of the insured or the party that has recently been joined as a co-defendant. Now, if it transpires that there are multiple parties, as frequently happens now in litigation, some of whom are domiciled within the jurisdiction and some of whom are not, a concurrent summons together with an original summons can be issued. And the very simple practical procedure for that is that it allows for different times for delivery of the appearance by a party that resides or is domiciled outside the jurisdiction versus a party that is inside the jurisdiction. So that is something, again, that we should consider if we are joining a third party. And it is also something that we should consider as a advisor of an insurer who's been joined as a defendant who is domiciled outside of this jurisdiction. And again, the summons should specifically state, following the application for leave, how long the period for entering an appearance has been granted by the judge. So it should say it specifically on the summons. And that is something that the court should address when the application pursuant to Order 11 has been granted. Now, in relation to the Hague Convention, I've decided just to deal with this first before I come on to the reason why I'm dealing with it, which is UK and Brexit. The Hague Convention is very simply a convention between parties to facilitate recognition of judicial determinations and also service between different jurisdictions. And there are contracting parties. And the contracting parties obviously are jurisdictions which stand alone, but having contracted to this particular convention, they are bound by it. The Hague Convention is in effect a framework for the service of documents between contracting states to the convention, and it's broadly similar to the transmitting agencies under the EU service regulation. So the EU service regulation obviously is something that is under EU law, and in particular, we would deal with that under Order 11A. The Hague Convention makes provision for the use of the central authority involvement in the process of service, and it avoids the need to appoint private agents to achieve service. So again, this is all procedural. Service of proceedings in countries that are not member states of the EU, but are contracting states by the Hague Convention of the service on the service abroad of judicial and extrajudicial documents in civil or commercial matters is governed by the provisions of that convention. And that is set out very specifically by Order 11E. Don't propose to go through that. It is clearly set out in Order 11E. But if there is a party that we wish to join as a third party to the proceedings, if it is a party that is not a member of the EU, is not a contracting party to the Lugano Convention, well, then we look at the Hague Convention, and if it is a party to the Hague Convention, we still must get leave from the court pursuant to Order 11, but then Order 11E provides for the manner in which service can be effected. Now, in January 2021, the UK decided that they no longer wanted to be friends with the EU. And I won't make any political comment on that. But the upshot of that in the context of service of documents was significant, because prior to this, the very simple procedure was that pursuant to Order 11A, if you were serving outside of the jurisdiction in the context of the United Kingdom, which obviously includes Northern Ireland. And it was surprising how many practitioners had a significant recoil following this, when very simply what was required was that under Order 11. And that is simply the procedure that is required now with any party that we wish to join to proceedings as intended third parties, or plaintiffs wish to join as co-defendants. We must now firstly bring an application for leave to issue and serve outside of the jurisdiction pursuant to Order 11. And that's it, very simple. Now, the United Kingdom did try to become part or rejoin the Lugano Convention, but the EU wouldn't permit them to do so. And what they are now relying on, and what we are relying on, is the Hague Convention. But the Hague Convention necessitates that we bring an application pursuant to Order 11, and that the tests that I've outlined previously, that it must be under a specific rule of Order 11, that there must be a good arguable case, and in addition to which that we must ensure that there is an averment to prove that the forum conveniens is Ireland. Now, again, a knee-jerk reaction in the High Court and also the Circuit Court, because so many of these applications came on after the 1st of January 2021. The courts did look quite vigorously and thoroughly at such applications. However, the courts, while still looking at them rigorously, they are accepted much more easily now than they had been. So, for example, last week in the ex parte list, quite a number of these applications were made. And during that time, the judge would simply ask the barrister, have you satisfied the criteria? Is it averred in the affidavit? And if the response was yes, the application was granted. So what we had after January 2021 has abated slightly when both practitioners and the judiciary have become more comfortable with the fact that we now have an extra layer to initiate proceedings against parties in the United Kingdom. So it's not as much of a hurdle as it was beforehand, but strictly speaking, the rules must be adhered to. And that's why I'm saying that even though the judges are now more inclined to do it, we still, as defendants, when assessing or advising from our client whether it's valid, have to assess the documentation upon which the application was successfully brought. In the Circuit Court, these applications are made pursuant to an almost identical rule. One small addition that I understand, the judge before whom these applications are made, he does require, for example, if you're bringing an application against a corporate entity, that a formal document would be exhibited, such as a company registration office document, to prove that the registered office is outside of the jurisdiction. So that's one additional requirement. Whereas some judges might accept an averment from the applicant, he does require an exhibit to prove that they are outside of the jurisdiction. You will see there that I have simply set out the grounding for why it is necessary. So Order 5, Rule 14 of the Rules of Superior Courts provides that no summons or other originating document for service out of the jurisdiction, or of which notice is to be given out of the jurisdiction, shall be issued without leave of the court. And that is why we must bring an application pursuant to Order 11. Moving on then, as I've mentioned a moment ago, the applications pursuant to Order 11 and then services pursuant to Order 11E. Just one point that I didn't emphasize there was in relation to a party not being domiciled within Ireland, where leave has been granted to issue and serve. Because we are a jurisdiction that is foreign to the party against whom the order has been granted, the rules provide that you do not serve the actual summons. You only serve the notice of the summons. This might sound utterly nonsensical and utterly unnecessary, but it's actually born from historical intervention between sovereign powers, where one sovereign should not summons another sovereign directly or citizen of a sovereign directly. And therefore, the practice is, and pursuant to the rules, the requirement is that it's a notice of the summons, not actually the summons itself. And this is rigidly adhered to. And if the summons in
You've lost your sound.
sorry.
I lost your sound there for a moment.
Is it back now?
That's better. Yeah.
Good. Sorry,
Okay.
someone probably deliberately tried to cut me off. The reason that this can be so technical is that a lot of the cases where we're serving outside of the jurisdiction tend to be high value cases, and the parties then try as best they can to avoid service. And when it can be a devastating blow to the proceedings in the context of statutes, that is why the hard work must be done at the very start on the ex parte docket, the grounding affidavit, to ensure that I's are dotted and T's are crossed so that any application to set aside will not succeed. However, it does appear at this stage, as I'd mentioned a moment ago, that the judges are much more willing to grant applications than they had been heretofore. Now, I had somehow volunteered to mention about third-party procedure when I was asked to talk about service outside the jurisdiction. And I've done that for the following reason. Now, in the paper, I've gone through in much more detail. No one needs to listen to me more than is necessary at this stage. But prior to, I think it was 2016, 2017, the third-party procedure was effectively adhered to without much test or probing. And then one or two defendants brought applications, one or two third parties brought applications to set aside third-party procedures. There's a case called Ashford Castle versus EJDC. And in that particular case, the defendant or one of the defendants brought an application to join a third party, and it was very late. And the third party, who, to be perfectly frank, is probably the party responsible for the damage to the castle. I'm involved in the case and I'm representing the insurer for the builder. They successfully got the case against them, or the third party notice set aside, because it was too late. So now, as defendants, certainly I've noticed coming across my desk is consideration of whether or not the application should be brought to set aside third party procedure. And the reason I think this is important is, again, we now have another layer in the context of proceedings against parties in the UK. And that has to be factored in as well, because that will take additional time. Now, the third-party procedure, as I'm sure you're all aware, it's effectively governed by Order 16, and that provides that it's 28 days within the delivery of the defence that the third-party application must be made. But then we have the statutory provision, which is section 27(1)(b), and that says that it is as soon as is reasonably possible. Now, the jurisprudence puts greater weight upon as soon as is reasonably possible, because obviously that's legislation and that takes precedent over the rules of the superior courts. And as soon as reasonably possible is based on the circumstances of the particular case. And in the Ashford Castle case that I referred to a moment ago, what actually transpired in that case was, in our defence, we expressly pleaded that this additional party should in fact be joined to the proceedings. And we delivered that to the defendant to say that they should bring the application. And that was almost 18 months before they did. So the judge was able to say, well, the intended party, third party, the identity of that party was brought to your attention at the time of the delivery of the defence. And that was the time that the judge deemed was to commence from the purpose of joining a third party. One of the things that's frequently confused in third party applications is in the relation to prejudice, and it's not actually a requirement. However, some of the judges do look at it, but it is technically speaking not a requirement to have to be able to prove prejudice if you're bringing an application to set aside. And the court simply looks as soon as is reasonably possible. But obviously, if there is prejudice joining the party, well, then that should be averred in an affidavit if there's an application to set aside. So what I've done is in the paper that Lawrence will be able to send on to you, I've gone into much more detail on that. But I just wanted to bring up third-party procedures in the context of serving outside of the jurisdiction, excuse me, because it's something that people are looking at much more frequently now. But I do think that a judge in an application to set aside a third-party notice will consider the additional requirement to bring an application now for leave as being reasonable. And by that, I mean that the timeline to do that will be considered when a judge is considering whether or not to set aside an application to join a third party. Okay, I'm going to stop talking. I'm sure everyone will be delighted to hear. If anyone has any questions, please fire away. And otherwise, Lawrence will send out that paper. And obviously, if anyone has any questions on that paper, you can contact me directly.
Do you have any questions, Tom? Nope. Oh, got Leanne Kiernan just arriving. I thought she was here already, actually. She must have left and come back. Oh, well. Anyway. Okay. Listen, thanks, Patrick. It's been fantastic. Really, really helpful, I'm sure, to all of the practitioners on the call. A little message there from Liz Lyons saying great presentation. So thank you very much for that.
That's right. I asked Liz to do that earlier. Thanks, Liz.
We will get the papers and the presentation round to you as soon as they're available. So thank you very much, everybody. Please keep your eye out for the next Foyle Island Learning event, which I think is on the 13th of July. If you haven't registered already, please do so. Thanks, everybody.
Thanks, Padraig. That was great.
Thanks,
Bye.
Padraig.
Thanks, guys. Cheers.
Thank you.